Hey guys, hey everybody. How are you guys doing? Hey. Let me put the link in for my folks to come in to do the reading. I have a couple of new readers gonna come later on to read with me. Guys, remember the young people? They said they'll come and read with us today. So later on once we finish the instruction reading, and then after that we'll come back after our prayer and then read the continuance of Daryl McDavid's testimony. All right, let me just put the link in for those to come in. Hey everybody. All right, so I decided to read the jury instruction hearing for so you guys will know what some of the things that they talked about in regard to the jury, um, what some of the rulings were. All right. All right, guys. Let me put on my thing so I can say hello. Hey, hey. Yeah, I gotta put some air on. Hold on. It's hot in here. It's hot in here. It's hot. Put the air conditioner on. Put the air conditioner on. All right. So we're not gonna be on too long because at 7 o'clock I will be starting the prayer. Um, okay. So we're gonna go ahead and start the Oh, thank you, Faith One. Thank you, Faith One. Appreciate you. Yeah, what is going on with the lights here? Whoop. I'm gonna miss my ghost back there when I leave here. I'm gonna miss my little ghost. I'm gonna miss my light ghost. Where's my readers at? Hey, let me say hi to people in the chat. Hold on a second. Where my folks at? Here's the link to come in, people. Here's the link to come in. Come on, come on, come on. Hold on a second, guys. I gotta send this to the folks. I'm gonna watching game, listening today, football Sunday. Oh yeah. Oh, with the hubby. Uh-oh, got the word hubby with the hubby. Again, congratulations with the hubby. All right, good people, let's get going. Where my folks at? Good help is hard to find. Oh, I just want to tell you guys, I want to tell y'all, I did get half a dose. I mean, let me tell you how good God is. I thought I was all out, and I had a half a dose. Had a half a dose of my medication. So I'm good. I'm good. I'm good. You know what? Where my people at? Oh, come on, folks. Where the heck? Good help is hard to find. I'm telling you, good help is hard to find, folks, y'all. I'm telling you. Good help is hard to find. Good help is hard to find. I didn't understand. I have to get off in a few minutes because I have to get in prayer. Hold on. Hold on a second. Let me find out where my peeps at. Where your butt at? Oh my God. I'm here waiting on y'all. All right. Bye. Tell you, good help is hard to find, y'all. Hard to find. Let me call the other one. Don't tell me you were asleep. I sent you the link to get in. I am. I am. I've been here. Ask everybody. You have been sleeping. Okay, come on, bye. I apologize. I have one sleeping, one getting the package. Good help is hard to find. I just want to tell you, good help is hard to find. So how's everybody Sunday afternoon? How's everybody Sunday afternoon, guys? You guys are doing well today? Well, as you guys know, I will be back in Chicago. Um, again, not next week, but the following week, I'll be back in Chicago. Not because I want to come back, because I have to come back for court. So I'll be back. I'll be back to Chicago. You counting down the time to get off, Kim? Wow. All right, let me say hi to folks in the chat. We got 89 folks in the chat. Hello, everybody. Welcome to the infamous Sylvia channel. I am your new trial blogger. And right now we're blogging and reading transcript from the current trial right now for Mr. Robert Sylvester Kelly. The trial has come to an end. No more testimony. The prosecution has rest. Defense has rest, and now the both sides will be doing their closing argument. Um, it's going to go first. It's going to be the prosecution, then defense. All three defense attorneys going to do their closing argument, and then the prosecution comes back for a rebuttal. Then the judge gives the jury the instruction, and then the actual the deliberation will start tomorrow. Hopefully, it will start tomorrow because the judge gave the defense 1 hour and an hour and a half. The government is 3 hours. So you guys gonna hear all that in the reading I'm about to do. So I'm gonna hopefully I get my people in here so we can reenact it because it doesn't sound good when it's just me reading it. You know what I mean? Because I can do the different voices, but I want you guys to feel it. You know, get the feel of it what we're doing. Okay. So let me see if I can get some folks up in here. Hold on a second. Hold on. Okay, my peeps are saying they're coming. They're coming, they're coming, they're coming. But anybody have any questions to ask me that you would like to know? Hey, Mr. Brentley.
Hi.
How are you? Mr. Brentley was sleeping, y'all.
Yes, hi. I'm sorry.
Mr. Brentley has had a good lunch slash dinner, and Mr. Brentley says, "Oh, I'm tired." So, did you got the email, right?
Hold on 1 minute. Let me look at my email. I just got this one here. Let me see.
The most recent one. That's the one we're gonna go with.
Yes, I
The
have
one I
it.
just sent you today.
Yes, I have it.
Okay.
Hold on. Hold on. I'm gonna get back out. I'm gonna go back because I'm gonna come back in on my phone. I'm sorry.
Okay. Hey Ashley, Sylvia, I'm a little late. Sorry. Are you okay? I'm good. I'm good. There was no altercation. I just got arrested. There's no altercation at all. Nobody did any kind of whatever rumor you're hearing. There's no altercation. There was no physical violence at all. There's no altercation. I just got arrested because someone lied. Hey Shantae. I said I was going to say hello to everybody in the chat, and I didn't get a chance to do that. Let me do that right now. Do you know it's a crime to file a false police report, guys? Did y'all know that? Do you know it's a crime? I got Jesse Smollett. I got Jesse Smollett. I guess it's a thing to do in Chicago, huh? Hey, Kimberly Black. Hello, Shannon Harris YTF. Hey, T Girl. Hey, Ashley Nelson Nisi Pooh. Hey, Rabbit 1969. Hey, Powerful. You know your butt need to be up in here. Where are you at? Hey, Faithful One. Hey, Bree. Let's see. Hold on. Did I miss anybody? That's it? Nobody else said any hello in here. Hey, Nosy Rosie. Hey, Vivian Clark. Hey, Arlene Harrell. Hey, Jackie Gaines. Hello, Lisa Cardwell. Lisa! Hey, Lisa. Hey, faithful one again. Arlene. Hey, Pete. One cool P, the married lady. Hey, Marietta Jones. Hey, Caribbean for Life, Carib. Let's see. Hey, Lady Coltrane. Hey, Mahogany, so Mahogany. Hey, Face by Lachelle Bay. Hello, Ashley Cashon. Okay, let's see. Hey, Keith Page. I'm doing fine, Keith. Thank you for asking. Hey, Angel. Hey, Lala Harrison. Hello, Shantae Lee Tomlinson. Hey, Angie. Hey, Bishop Don Juan. Hey, Rhoda. Hey, Miss Fad. Hey, Valerie. Big B's in the house. Hey, Riddy Co H. Hello, welcome. Your new name. Hey, Shamika Harris. Hey, Miss Leo YTF. Let's see. Is anybody? Hey, Too Cute. All right. We here, but my people are not here. We got two more persons that I'm waiting for, but we can get started because I don't want to hold you guys too long because I have to start our prayer. I have the prayer link coming on at 7 o'clock, and I am not going to miss that because that's important. I don't care where I am. I don't care where we leave off. I am not going to miss prayer. Okay. I'm just going to tell you that right now. I am not missing my prayer. Okay. All right. Let's get started.
What page you want to be on?
Starting from the beginning. 35555. Hey, Orny. Oh, one H. Hello, welcome. New name. Hello. I'm so glad you're here. I hope you hit the like button when you came in. And if you have not, please take the time to hit the like button and come on back in here and stay for a while. I hope my Southern hospitality really is something that you would gravitate you to staying on this channel. Okay. I'm not a real Southerner, but I became a Southerner. I'm a New Yorker, but a Southerner, but by way of Caribbean. Okay. So I'm a little bit mixed up. I'm one of those what you call mixed mutts. Hey, Donna, well, I'm a mixed mutt. I'm mixed with everything. Name it, I am it. I'm everything. All right. Where's my lady at? Hey, powerful. What's up? We need to get going, lady. Do you need a link to come on in? Hey, Jasmine, where have you been, young lady? Are you singing your heart out? Oh, you've been following since 2016? Following who? I haven't been on since 2016. Following who? Who you been following? Wasn't me. As Shaggy said, wasn't me. All right. Not me. Not 2016. Okay. Unless you're somebody I know that using a different name. Are you somebody different? All right. So let's start off, and I'm gonna read. And hey, Daphne. Tamiria and I is going to just play all different parts, okay? We're just going to play it until somebody pops in and help us out, okay? All right. The United States District Court of the Northern District of Illinois, Eastern Division, United States of America plaintiff versus, oh, okay. Robert Sylvester Kelly, a.k.a. R. Kelly, Daryl McDavid, and Milton Brown, aka June Brown. Ma'am, you in that noise back there, ma'am.
Dang, you hear everything. I can't even move the chair. Dang. Come on now.
Case number 19. See, if you were in court, the judge would be like, ma'am, get out. Okay. Case number 19 CR 00567, Chicago, Illinois, September 9th. at 2 p.m. All right. And this is a redacted report. We're going to start off now. You could be Miss Pelosa.
Okay, we have one thing to address with this court.
Yes.
We are going to make the request that the individuals at McDavid's counsel table stop gesturing yes and no to him when he looks over during the questioning. What?
You got to be kidding me.
No, I'm not kidding. Unfortunately, I'm not, and I wish I was. But our case against is seeing his behavior happening, and we're going to ask that it stop for the rest of this examination.
Well, since it didn't happen in the first place.
If it didn't happen, it didn't happen. It won't continue to happen.
Absolutely.
Let's get the jury in. They're out in the hall.
Okay. So guys, what we're gonna do is gonna continue the cross-examination. But no. Do you want to do cross-examination continuing? Because I really want to get to the meat and potato of the what's the name?
Whatever you want to do, Sylvia.
Okay. So let's go all the way down. Sorry guys. I want to go down to where we I apologize, but I'm not doing the testimony. I want to talk about the
Did the people want us, or they just want us to go down to?
we're going down. We're going down because we're gonna come back and do the testimony. But I want to read the jury instructions so they can understand what the rulings were with the judge. Okay.
Cross the jam that bone.
Okay. He says he's finished at
What page?
3609. Okay, you can go ahead and say that.
Hold on, let me get to it, Sylvia. I don't know why mine's so slow. 3609. Hold on.
Thank you guys for being here. I appreciate it. What we're doing now, we're reading the part where the jury instructions, so we will know what some of the things that they discuss about what is allowed and what is not allowed. Okay.
Okay. I'm finished, Judge.
I know. I'm just asking.
The government does not have recross.
All right. The witness says, all right, you can step down. Any further witnesses and evidence from the defendant, I believe?
We have a stipulation.
Miss Judge, you have something?
No, go ahead.
Yes, Judge. I have a proposed piece of evidence, my client's passport, defendant exhibit Brown 103. Any excuse me. Any objection?
Yes, Your Honor. The government objects. The passport is from well after the change in the case, so it's absolutely not relevant evidence to anything involving the trial.
The indictment states the years that my client was employed for Mr. Kelly, and the passport encompassed those years. All right, I'll admit it over the objection. Exhibit defendant Brown 103 received in evidence.
Judge,
Anything?
we have a stipulation. I'm just looking for it. I think the government, Miss Bonjane, I think I have the signed one here. Okay, thank you. One moment. Can you hear me, Sylvia?
Yes, I'm sorry. I was trying to turn my phone down. People calling me. I apologize. Now, what were you saying? Sorry.
I said, okay, thank you. One moment, please. One moment.
Okay. Who is going to read the stipulation? I am. All right, Miss Cohen. It's Miss O'Connell, actually. Thank you. I
I
have.
have.
Go
Go
ahead. You
ahead.
did. Go ahead. You do that one.
I have a stipulation with regards to the
All right. Go ahead, Mary.
passport.
All right. Read it. All
You want me
right.
to read it?
Read it.
It is hereby stipulated to and agreed to by and between the United States of America, its attorney John Lurch, with the Northern District of Illinois, and defendants Mr. Robert Sylvester Kelly, Mr. Dale McDavid, and Mr. Milton Brown, that the following facts and should be considered to be true and accurate. Stipulation: Brown Defense Exhibit 103 is a genuine United States passport issued by the Department of State to Milton Brown on April 5, 2011. The passport was given to the government on July 12, 2019, pending the outcome of this case. Although the passport was current at that time, it has since expired on April 4th, 2021. The passport includes a photograph of Mr. Brown and stamps indicating various dates of international travel. Shall I move that into evidence, Judge?
Fine. Stipulated for Mr. Kelly. Thank you. It is hereby stipulated to and agreed by and between the United States of America by and through its attorney, John R. Launch Jr., the United States Attorney for the Northern District of Illinois, and defendant Robert Sylvester Kelly, Darrell McDavid, and Milton Brown, that the following facts are and should be considered to be true and accurate. Stipulation: Hypnotic is an alcohol beverage that was first introduced into commerce beginning in September 2001. So stipulated. Okay, further evidence? We would move that into evidence. Further evidence from the defendant?
No,
None.
none from Mr. Kelly.
How about Mr. McDavid?
At this time, Mr. McDavid rests, Your Honor.
Miss Judge, on behalf of Mr. Brown? Mr. Brown rests as well. Is there any rebuttal?
Your Honor, the government needs a few minutes to discuss and outside the presence of the jury, if we may.
Well, excuse me. Okay, we'll take a 15-minute recess at this time. Proceeding heard in open court. Jury walks out. Okay, outside the presence of the jury.
Yes, Judge. I'm sorry. I should have clarified. We just need some time internally to discuss since Mr. McDavid just ended his testimony to see if there is going to be any rebuttal evidence.
All right, well, then we'll have our 15 minutes and then have the witnesses ready to roll. If not, we'll send the juries home until Monday, and we'll complete the instruction conference. We'll do that anyway, regardless of whether we have any rebuttals.
Yes, Your Honor. We'll report back in a few minutes if that's okay. Judge, may I make a request? I'm dealing with the MCC about visiting Mr. Kelly this weekend. We've actually had no ability to visit with him because they suspend visiting at 3 o'clock, and there's no visiting on the weekend, which has preclu- precluded precluded me from visiting with him at all throughout the trial. We've made do by visiting at lunchtime or in the morning. But my understanding is that if the court issued an order to accommodate so I can visit with him before closing arguments on Monday over the weekend, I would ask that for that.
All right. I can. Can the government assist in communicating with the marshals? I will. I think it would be necessary so that we can, because I have been under pressure to get this case finished. And so in order to accommodate defense counsel, I'll order that they make some accommodation for her to visit Mr. Kelly prior to 10 o'clock a.m. Monday.
Thank you, Your Honor.
And could you assist in communicating that with the marshals?
Yes, Your Honor. Judge, will you? Judge, we will. The order from you is really the key, I believe. We can, talk to them, but
Yes, we can tell them that I'm ordering it.
yes, Judge.
Whether I have the authority to order it or not, I'm ordering it. That's the problem with the division powers. You end up not having having very many. Recess from 3:22 to 3:40 p.m. Change court reporter. Okay. All right. Hey, Perspective. Thank you for coming. We're on page 3615. You could jump in wherever you want to jump in.
Hello. Who would you like me to read?
Or you could be anybody
Hello?
you want to be.
4615. Tamaria, who do you want to be? And I'll opposite you.
Um, you can be Peloso. I can be the court.
Peloso? Okay.
Mhm.
All right. Is everyone here? Yes?
Ooh, wait, I gotta get to the page. I'm so sorry. 35, 36, 16,
15.
15.
15.
Line number 3.
Line number 3. Okay. Yes, Judge. The government is asking for some time to meet and discuss a rebuttal case. If we do proceed, like I said, it would be very, very brief on Monday morning. I understand Your Honor's concern, but the defense case ended today. There was some information discussed that we're talking about, and we're just asking for additional time given that it's almost 4 o'clock to discuss that and get the witnesses here. If we do have witnesses, of course, we'll be communicating with the defendant, as soon as we solidify.
Well, tell me
Well,
what's the evidence. What's the material is what the material is that you're going to be. What's the subject of your possible rebuttal?
It's related to Mr. McDavid's testimony, related to some of the individuals discussed. And I'm not at liberty to confirm anything right now because we have to talk to the concerned people that we may call to see. So we just need additional time, Judge. We need some time today to iron this out. And we're requesting to be able to present that Monday if we do proceed with that.
No, I'm not going to do that. We either do it today or not. Uh-oh.
Okay, then we will need time to discuss because we don't have the witness here. We just need some time to discuss, Your Honor. And if we don't have that time, then we're hamstrung to proceed essentially.
Judge, I mean, Mr. McDavid's testimony over the course of the last 2 days, nothing he said today was inconsistent to this. He's just keeping restating his position over and over again. So if they had someone in response, what they said, they should have been here now.
Well, I think too. I think so too. But if there is a report that you feel established some basis for being different than what he testified to, maybe you can stipulate the report is what it is. I mean, what it says.
Okay,
I don't know.
I'm sorry.
I don't know if they can or not, but that would be, otherwise I'm going to close. If you will tell me precisely what it is that
Okay, you're gonna
Um,
be the judge. Hold on, y'all. You're gonna be the judge, Tamiria. Henny,
mhm.
you're gonna be Palozzo, and perspective, you're gonna be Jennifer. Okay?
Oh,
oh, okay. I'm gonna switch.
what page?
Yeah, Jennifer, Palooza. We're on page 3616. 3616, and I'll be the judge. Everybody got that? No, you're the judge, Tamiria. I'm sorry. You're the judge.
Right. Okay.
Okay, everybody got their part?
And I'm
Yes.
oh,
And I'll just be Brittany or whoever else.
okay.
All right, go ahead, guys. We're on line number 16.
16.
Oh,
Palooza, that's you.
yes, yes, Judge. So I mean, we do have grand jury testimony from individuals that we would gladly offer in reports. But in particular today, Mr. David was shown Mr. McDavid was shown letters related to Barry Hankerson. He did not, recognize them. And so Barry Hankerson is someone that is on our list of people that we may call to discuss those matters. So that's what we're talking about here. We have those letters. If those are admitted into evidence, that would be part of the reason that we're calling Mr. Hankerson.
What
What
letters?
letters?
I'm sorry.
Two letters that were written by to Gary Mongolis that appendage showed the witness. He stated he didn't know what they were, and that is one of the topics of rebuttal case that we're discussing, calling Mr. Hankerson to testify about those issues.
Judge, first of all, that was a letter written. I'm sorry, Bu, but it was a letter written from someone on behalf of Mr. Hankerson to Mr. Margolis. Why would Mr. David McDavid have ever seen a letter that was not even addressed to him? And I don't know what bringing Mr. Hankerson in. I mean, again, I think they're trying to bring in evidence about his niece again, Aaliyah, which has been barred by the court already. I can't imagine the whole Hankerson thing went to Mr. McDavid's state of mind. I don't know what Mr. Hankerson has to say could even possibly be relevant to anything in rebuttal.
Judge, the point I would make is that Daryl said that he did not see the letters and didn't know what they were. Mr. Hankerson could not possibly rebut that. Mr. Hankerson does not know what Daryl McDavid saw. And I think it would be weird if he did see those letters necessarily. I don't see why he would have, since he didn't deny. All he denied was that he had ever seen them and he knew what they were. I don't even think this would be a appropriate rebuttal. I think we would probably object to it. Miss Miss Your Honor, they're introducing numerous amounts of documents that were not written to Mr. McDavid or by Mr. McDavid. He read a lot of things and formed opinions of those things. There were things that were communicated to the attorneys, Gary Mongolis, that has, been so prominent in his testimony. We're entitled to explore that in rebuttal. And that's what we're asking for, is to, we want to admit those letters and we can redact Aaliyah's name. We're not trying to.
I'm going to cut this. We're going to close the proofs today. If you have further evidence, present it. If not, I'm going to rule that the proofs are closed. And I'll bring the jury back and instruct them to be here at 10 o'clock for the final arguments. That's my ruling. So can you have them bringing in the jury? I mean, can you have them bring the jury in? We'll send them home then. Does everybody have the red line and the instructions? Because I'm going to list what we did and then let you make your objections as to my ruling, which we made before, if I can't figure out my notes. Please be seated. It's my understanding the fence rests. Is that correct?
It is.
Yes, Your Honor.
Yes.
On behalf of defendant Kelly, the defense rests.
Yes, Your Honor. Defendant Kelly rests.
And Mr. McDavid?
On behalf of Mr. McDavid, we rest, Your Honor.
Brown?
Mr. Brown rests too, Judge. Thank you.
Okay, does the government have rebuttal testimony?
No, Your Honor.
So proofs are closed. Members of the jury, we will now suspend until 10 o'clock Monday.
You went out, Tamiria. Tamiria, you went out, hon.
Can you hear me now?
Yeah, I
Yes.
can hear you.
Okay, I'm sorry, my phone rang. We will now
Monday.
suspend. Okay, we will now suspend until 10 o'clock Monday, and you will at that time hear the closing arguments of the attorneys. I will then instruct you as to the law. Then you will retire to consider your verdict. It's very important that you follow my instructions, not to read about the case and not to discuss the case among yourselves or with anybody else until after this case is over. So have a nice weekend. We'll see you Monday at 10 o'clock a.m. Please be seated. No reason to stand.
Judge, may I waive Mr. Kelly's appearance for this portion?
Okay, yes, Mr. Kelly may be excused if he chooses.
Mr. Brown is going to leave as well.
Mr. Brown, if he chooses to leave, may go.
Thank you.
All right. Let the record show that the court met with, well, in open court, it says on the record, several days ago and went over all the instructions that have been tendered by all parties. And the court indicated at that time, after hearing arguments of how the court would rule on the respective instructions that were tendered. And the court said at that time that I would give you time to state your objections to those that you find objectable. So what I propose to do, starting with the government's instruction number 1 and proceed through all of the instructions that were tendered and indicated how I ruled, and hear your arguments and possible corrections if I misunderstood somebody. Is that okay with everybody?
Yes.
All right. The government's first 7 instructions were, there were no objection given. They were the stop ones. Number 1 was 7th Circuit 101. There was no objection given. Number 2 is 1.02, no objection given. Number 3, 1.0, no objection given. 4, 2. You want me to read that? Can you hear me?
Yes. Keep going, ma'am.
Oh, okay. 4, 2.01, no objection given. 5, 2.02, no objection given. 6, 2.03, no objection given. 7, 3.01, no objection given. 8, 2.04, there is no objection as given, and the brackets are removed. Number 9, 2.05, there is no objection. It's giving, and the brackets were removed. Is that correct on that one? Maybe I better give you that one. While we check, is that right? All right. Number 10, 3.09 is written down. Is withdrawn. 11, 3.13, no objection given. And we filled in the bracket with what was it the names.
Number 10.
Number number 11, 3.1, I mean 13. I think, isn't that the expert?
Yes.
Yes.
I'm sorry, Judge. Which instruction are we on?
I think you're reading numbers from the proposed one, and they have been renumbered in the packet we have now. We now have.
Well, there are the well, these are the original ones.
Okay.
We're on current instruction 10.
All right, I'm going on my notes. Anyway, the bracket was to name the expert. Wasn't that it? And that was no objection given. Number 12, based on US versus Young, there was an objection and that was refused. Does the government wish to argue that? I think it was the government that objected, or maybe it was the defense.
I think it was, I think I objected. I could be wrong, but it looks like I objected.
We should not stipulate why any other person whose name you may have heard during the trial is not currently on trial before you. I can't remember. I didn't write down who objected.
Yes, Judge. I think I objected on behalf of Defendant Kelly. Um, was that there was no basis?
Okay, it was Kelly then.
Yes. There is no basis to include an instruction unless the defendant argues that he should be acquitted because the government failed to charge somebody else. I think that was our basis. That if
Okay. Anyway, I refused it. So does the government wish to argue that? Hearing none, we'll go on. That's refused. 13, 3.02, no objection given. 14, 3.14, no objection, was modified. What was the modification?
14, you say?
It's number 14, yes. We removed the second full paragraph and the last paragraph, leaving the first and the third paragraph, according to my notes. There was no objection with that modification. Number 15 was 3.16, and that was no objection, and that was modified. What did we do on that? Number 3.16, which is government's number 15 originally, it was old number 15.
Is that the chart and summaries?
Charts and summaries, yes. There was no charts, I think. Wasn't that it? One or the other?
We made it charts.
summary charts, I think we did we?
We made it charts rather than, that was the modification, and my notes indicate no objection. Number 16, 3.17 was withdrawn.
You blanked out again.
You blanked out. You blanked out, Tamiria.
Start at
you
line
hear me?
7.
Can y'all hear me?
Yeah.
Yeah.
Now.
Okay, I'm going to line 7. 17, which is 3.18, there is no objection given. Number 18, which was 4.06 and 4.07, there was an objection by Kelly, and my ruling was to give it modified without the bracket material.
Yes, that's over our without it right, Judge. That's what you ruled.
Pardon?
You ruled to omit the without the bracket information.
Without the bracket.
Okay. I think that's over our objection, just for the record, right?
All right. Number 19, this is 4.05, no objection given.
Your phone blanked out again, ma'am.
You can't hear me?
I hear you.
You blanked
Do
out
y'all
for a
hear me?
second.
I hear you.
Everybody hear me, Sylvia?
We hear you now. We hear you now, but you did blank out.
Okay, what was I at?
All right. You didn't say all right.
All right. Number 19. This is 4.05. No objection given. 24.10 objection given. Modified by adding, what did we add there? I can't read my writing. Person under the age of 18, and we excluded the minor definition.
I think we took out minor because we were going to incorporate it.
Yeah, because of the problem between a minor being 18 and then the other count where it's 17. So we decided to eliminate the definition of minor and just add a person under the age of 18. What number was that again? That was 20, and there is still an objection. I didn't write down who objected, so to it. Anybody remember who?
Which part, Judge?
This is 4.10.
Yes, Judge. If this is the definition,
Yes, definitions.
yes, I think the court allowed to include the definition of producing, just as the government included the definition of other.
Yeah, I do have that. Was that done producing? I did write down producing, and
That comes from 18 USC 2256-3.
according to my notes, it should have been, but I don't see it in there. So,
Right.
well, we'll add that. Does that eliminate your objection?
I think the only other issue was whether or not the government wanted to think about whether they were going to persist with including the sadist or massive massive sadist abuse in the sexually explicit conduct definition.
Tamiri, could you mute? Because there's some noise in the back for us. Yeah.
It's her line though.
I don't know. My phone just started acting up. I don't know. I got my earpiece in, but the phone is static. Okay. Can y'all hear me now?
Yeah.
Yeah.
Okay. Go ahead.
It's your line 4.
Oh, it's happening again. I'm gonna go back out and come in. I don't know.
Okay.
Let's see.
We objected to that to that part of the definition because the comments say suggest to remove any that don't apply. And I think the government said that they wanted to think about their response to that. I don't know. Is my recollection anyways?
I don't indicate that was left open, but you don't want the entire paragraph of sexual explicit conduct. The definition of sexual explicit conduct. That's what you're talking about, right?
Yes, number 3. I don't think it is applicable. Just like bestiality isn't applicable here.
That's right. Does the government take out sad? Oh gosh, I don't even know how to say it. Sadist and masochist abuse.
Your Honor, you know we are fine taking it out. That's fine.
You sound
Okay.
just like them.
Okay, we'll take out number 3 and renumber. Next number is 21, which 18 USC 2251A. That's given a modified by adding J. I indicate no objection on that. 22 5.09, no objection given. 23 5.10, no objection given. 24 U.S. versus Holiday, objection refused. Which was that? And Hidalgo, not Holiday. Number 24, I refused it. I don't remember. It should be in Hidalgo.
Hidalgo Sanchez.
Is that it? It was defendant's. Okay. What is McDavid 7? Maybe that was it.
That's mere presence and association.
Pardon?
That's mere presence and association.
Yeah, I think maybe I refused it in favor of yours. I think that was it.
We offered it and it was unopposed, I believe.
Yeah, I think we refused it.
Right.
Pardon?
Yes, I think the Hidalgo Sanchez was refused in mere process was.
We have it now. The government need not prove the defendant was aware of or played a role in every act of the conspiracy. Defendant knew every member of the conspiracy. Instead, the evidence need only show the defendant was aware of the aim of the conspiracy and made a knowing decision to join them. That's the original. And there was objections, and my notes indicate that was refused. But what is the current 24?
Judge, my recollection was that Mr. McDavid offered the entirety of the pattern mere presence instruction. The government did not object.
Is that your number 7?
Yes.
Yeah, I think that was it. I think I refused the government's 24 in favor of McDavid's 7, I think. You indicated we didn't refuse that, huh?
I have it in my notes, Judge, that we objected to it. Defendant Kelly objected to it as the non-pattern instruction. We objected. I don't know, frankly. I don't have recollection of how the court ruled, though.
Well, I definitely have, and I wrote down refuse, but the red line version doesn't show that. For number 24, that U.S. versus Hidalgo, that's left. What's left?
Judge, we removed that from the updated version.
That's our notes, that the government removed that one.
It was over our objection. We took it out.
Okay, that was it. Okay, number 25, 5.08a, that's given as modifier. Apparently no objection. I don't have any objection. Is that right? Yeah, 5.0808a. That what was the modification? A defendant may not be convicted of a conspiracy by terminated more than 5 years before the indictment, which was returned on July 11, 2019. A conspiracy terminates when the charged purpose of the conspiracy is obtained or abandoned. That wasn't in my indication. Is that's given as the way that's written? I read it. I don't have an indication of an objection.
Yes, Judge, I believe we objected to that, but we added it. So if it follows what used to be government proposed instruction 25 as the elements for count 5, which were given with some modifications, and then you gave that is to McDavid's proposed instruction that was given at least in part as the next instruction. So what we've read is what we have in our set.
Okay, number 26, which is section 1519. There was an objection. There was objection? It was modified by combining, I think, 2 paragraphs, 2 and 3, adding, I can't read my writing, combining 2 and 3, okay? All right, according to my notes, there wasn't objection, and I indicated I believe I would give it as modified. Anybody wish to object to it?
This is our objection, right, Mike?
Sort of.
Judge, We had an alternative version. So for the record, we'll object and say we asked for our alternative version.
All right, that will be refused, and I'll give that. Number 27.
I'm sorry. The defendant Kelly joins with defendant David on that, Mr. McDavid on that.
Okay, a definition of something. What is 27? We removed anything? We removed something? Tangible objection, definition of tangible objection for count 5. We modified
Object.
because tangible object, I'm sorry, tangible object, definition of tangible object for count 5. We modified because we moved an agency of the United States, including Homeland Security, in an investigation of matter within jurisdiction of an agency, etc. There was objection to the modified. Does anybody wish to state on the record basis for objection?
Yes, Judge. The government does object to the removal of the third paragraph.
Okay, number 28 was withdrawn. 29, double jeopardy was refused. 30, I don't have what it was refused. What was 30?
Polygraph.
Polygraph, yes.
Polygraph?
I refuse that. Anybody want to argue that?
No, Judge.
31, Court 6, 5.08b was given without objection. 32, Count 6, Section 2252A, A2, giving no objection, modification of the spelling of Mr. McDavid's name. Objection wants to object to the modification.
No.
No.
Number 33, count 7 and 8, given without objection. 39 or 34 was refused. 35, 5.06.
Judge, we held off on this one. The government is requesting that this be added. Section 2 is alleged in the indictment for count 7 and 8. And so what we had discussed was adding at the top for purposes of count 7 and 8 because the evidence as it's borne out throughout the trial is that Mr. McDavid, had, and this relates to the receipts charged in count 6 or count 7 and 8. So we are asking to include this. We held it to abeyance. We're asking to include this count 7 and 8. That's the government's proposed 35.
Okay, that was refused. Okay, 35, 5.06 adds tentatively withdrawing. That's right.
Yes, we're asking that it be given, Judge.
Begs, counsel, commands, induces, or procures the commission of an offense and may be found guilty of that offense if he knowingly participates.
Judge, Judge, this is the court or the instruction that I think we argued. It's really not been the government's theory of an aiding and abetting type of theory. All alleged that every single defendant had a particular role or direct participation. And there was really not been a theory of, some sort of legal accountability that way. I think it's inappropriate under.
I always wonder in a conspiracy case why you need both, but
This is for.
it's usually given. It's tentatively withdrawn. As I understand now, they don't want to withdraw it, so I will give it. Anybody object? State your objections.
Judge, my objection is that with respect to Mr. McDavid, at least in terms of count 7 and 8, the government's argument, though their witnesses has been that he personally received the item So you can't have it both ways. If you want aiding and abetting, you need to make that your theory of the case with the prosecution. In this case, their theory of the case is that he received the videos himself. That's what their witnesses said. Now, if they don't like, they find their witnesses weren't very believable or whatever, that may be a problem. But the bottom line is their theory of the case has been, and with their witnesses, has been that he received the videos himself.
Okay.
And Your Honor, just to add to that, I think the court pointed to something that this is conspiracy. And it seems to be in conflict a little bit with this instruction the because the overt acts, you know, can be by any co-conspirator. So it's already sort of embedded in that instruction. And I don't think that it's appropriate in the way they've charged this case, in the way they have put in their proofs that this instruction be given. And I join in Mr. Bradley's objection.
Brentley.
Brindley's instruction.
Okay.
Sorry.
That will be given over your objection. 36, section 2422B, counts 9, 10, 12, and 13. There is an objection. Modify adding pseudonyms and modify paragraph 4 also adds language. Let me see.
Blanked out.
You blanked out again.
Start at 7.
She must got a phone call.
She went on mute.
Okay, I'm here.
7.
I'm sorry. 7. Okay, by adding and as defined in the following instruction.
That's correct, Your Honor.
In paragraph 4, somebody objected, maybe Kelly.
No, I think Judge. I had just suggested that we use the pseudonyms as opposed to the words minor. That was my objection.
All right, y'all go ahead. I have to get this call.
All right.
All right. You
I
want to
think
do
the
it?
court agreed that was changed.
Okay, I'll give it, modify it with the pseudonym. All right, 39, count 11. There's an objection that's given. I don't remember who objected.
Instruction. I'm sorry. Government instruction 30.
9?
37.
And it's as count 11. Another one of the count 11 instruction.
I don't think we did 37 or 38 yet, Judge.
I think we might have skipped some. We just finished 35.
This is 36. All right. 35 was given. Originally, the government was going to think about it, and they wanted it. They want it, and we'll give it. So 36, section 2422, which is count 9, 10, 12, and 13. I indicated I was going to give it as modified by adding the pseudonym and adding the paragraph 4 language. Is that right? The number 36?
Correct.
That there's somebody objected?
I think we're good on that one, Judge. I think we just went through that one.
Okay, 37. I don't remember what the source is, but there is an objection. I indicate I would give.
Yes, Judge. Just for the record, Defendant Kelly had objected and had proposed the Illinois pattern jury instructions for the elements of that offense.
Okay.
And I think you overruled.
Okay.
And that's our objection stands.
The objection is overruled. It'll be given. 38, count 11, section 2422B, modification by adding pseudonyms. I indicated it would be given. I don't know if there was an objection to that. 39, count 11, section 2422B, modification by adding pseudonyms. I indicated it would be given. 38, count 11, section 2422B, modification by adding pseudonyms. I indicated it would be given. 39, count 11, section 2422B, modification by adding pseudonyms. I indicated it would be given.
Just defendant Kelly had proposed using the pseudonym and taking out minor. That was the only.
Okay,
Okay.
39 as of account 11, there was an objection, and I indicated that I would give in that.
Correct.
All right. 40, consent was withdrawn. 41, 4.08, no objection given. 42, 7.01, given as modified. What was the modification of 42? 7.01. We eliminated the bracket material. The note should include the date and time. Okay. What number was that?
41.
41. That's 4.08. 42 is 7.01. That's given as modified. I don't know what the modification was. Apparently, there was no modification. Don't give the breakdowns of the note, of the vote. 43, 7.02 is given, no objection. 44, 7.03, given, no objection. Verdict form, it's my understanding the only request was they have the not guilty first as opposed to the guilty.
Yes, Judge. Yes.
I said, well, do that.
Well, make the change, and the judge on 43 for the bracketed, just as we are cleaning these up. How do you prefer, for the bracketed material on 43, what is your preference in terms of reading the verdict? Are you going to read the verdict form, just so we can clean up the brackets? I just wanted to get your.
I will, yes, make that. I'll read it. All right. Now there was a 45 added telephone concerning there was an objection. I indicated I was going to give it. A telephone is an instrument of interstate commerce. So I know there was, I think, united objection on this side of the courtroom.
Yes, Judge.
McDavid number 5, let's see, what was that? Is replaced by court 1 and court's instruction. I think is 1. Didn't I rewrite it?
You did.
I rewrote it and everybody didn't like it, if I remember right.
I strenuously object, Your Honor, but I have no specific complaints about your.
I think the government objected and all the defendants objected, so I'll give it number 6. McDavid 6 is refused. McDavid 7 is given without objection. McDavid number 8 is modified by adding Jane and Susan. And number 9 is given without objection. Then we get to Brown. Number 1 was withdrawn in favor of McDavid. Number 7. Number 4 has been briefed. I read the briefs and I think the government has the edge in this, particularly on the basis of the United States versus Kern, which is the 10th Circuit case, which makes the point that there is, I'll tell you in a minute, and the point. There is a distinction between the elements of an offense and the means by which the government may satisfy an element. The element is child pornography, and that means of satisfying that are the respective videos 1, 2, 3, and 4. And according to the 10th Circuit, the jury need not agree anonymously on the means by which the element is proven. So the instruction tendered by Brown will be refused. And I don't think the 7th Circuit has, well, it certainly hasn't in this context. So you have your objection noted in the record. And so your number 4 is refused. Are there any other instructions?
Judge, we added in the revised set that I sent your law clerk. We added for purpose of count 6, 7, and 8. The term minor means a person under the age of 18. I'm under the age of 18. We realized as we were putting these together, that we do need to, address what a minor. Minor for those counts is under 18. And then, as we discussed at the last conference, for the other counts, we've used the names and then the ages so defined within. So that's an additional instruction that we proposed when we circulated them to everyone. So I don't know if you want to we just have a couple things. So if you want to address that one first, if anyone had an objection to that.
I'm sorry. Which instruction number is it?
So in the new set, it was instruction number 31 to follow count 6, 7, and 8. The patterns use the term minor.
I remember we had a lengthy discussion because of the fact that pornography is what, 17 or under?
So some of the counts it's 18 and some it's 17. So we're just specifying what it is.
Yeah.
Because otherwise there is no definition for a minor in those counts. And so
I thought we took care. Let me see.
I'm not sure I think that's unnecessary because you've already defined child pornography with that age of under 18. It's already incorporated in the child pornography definition.
Which counts? Which counts are?
it's 6, 7, and 8. And so it's confusing because when you look at government instruction number 32, for example, which is
32, 33?
the proposed 32, it says, for example, the third element is the person knew both that the material depicted one or more minors, and so, and the same goes for count 7 and 8. The defendant has to know the videos depicted a minor and for these counts, it's 18 and under.
Yes, but child pornography has been defined as a person under the age of 18. It's just duplicative. It's in the definition of child pornography.
Wait a minute. The count? Which one? Let's see. Enticement of Jane, Nia, Paula, Brittany, counts 9, 10, 12, and 13. In order to find the defendant guilty, defendant used the facility, etc. Nia, Paula were less than 18 years of age, and defendant believed that Jane, Nia, Paula, and Brittany were less than 18 years of age. I don't think you need to have.
It's count 7, 6, 7, and 8, Your Honor. Then I think we have to add the age.
Wait a minute. Okay, let me move to 6, 7, and 8.
It actually does raise a good question, though, about
6, a person knowingly receives. I think that clarification is helpful. So I'll overrule the objection and give that. What else?
Judge. You just pointed something out that I think could lead to some confusion. As you pointed out in the enticement counts 9, 10, 12, and 13, it instructs the jury that they have to find Jane, Nia, Pauline, and Brittany were less than 18 years of age. They also have to find that they committed the offense, or that the defendant committed the offense of aggravated criminal sexual abuse, which, as we know in the next instruction, is the government has to show that the minor or the individual was under the age of 17. So the jury is going to be, I think, confused that, well, which one is it? Is it 18 or 17? In fact, it's 17, because you have to prove aggravated criminal sexual abuse, you have to demonstrate that they were under 17, not 18. So it's one of those just weird circumstances where the actual offense, the sexual activity that's being charged, has a different age for a minor than the rest of the.
Well, I think it's clear when you read, well, I don't know if it's clear or not, but it's clear then, for 9, 10, 12, and 13, who is less at least 13, but under 17.
Right.
So that doesn't mention minor at all. It just says that the victim is at least 13 under 17. And in the other court, I mean, obviously it's confusing to have different ages for different counts, but I don't know what we can do about it. I think that it's reasonable clear by adding the definition of minor. So I will overrule your objection of that. What else do we need to do?
Judge, there is just one more, and that is the government's request to include the hearsay instruction as you give it today. Given there is going to be a lot of argument on the evidence that came in for state of mind and how, you know, it's going to be factored into the purpose for which the jury can review it. So we think it would be very helpful for the jury to have that instruction with them when they're reviewing the evidence.
And we would ask to renew the 404B instruction.
All right, we'll put both of those in. It makes more instructions to read, but I'll accommodate you on both of those. So we'll add those.
Thank you, Your Honor.
Anything else?
Not from the government,
Not from Defendant Kelly.
not
Not
from
from
Mr.
David.
David.
Not from Brown, Mr. Brown.
All right, our instruction conference is officially over, and we will argue the case 10 o'clock Monday morning. How much time do you need?
So, Judge, the government is asking for both of our arguments for 4 hours combined.
4 hours.
That's too much. They won't be able to add. I'll give you 3 hours.
For open, for open, close, and rebuttal, Your Honor.
You're not supposed to do that.
I'm sorry.
Yes, because I want to get it all in one day, with breaks and stuff. How about Kelly? How much time do you want, Kelly?
Well, Judge, I tend to be short, but I mean, I do think that I couldn't. I mean, I think 90 minutes to 2 hours for 13. I mean, I have 13 counts on this indictment, so at least 90 minutes, frankly.
90 minutes. 90 minutes for McDavid. I'll give you 90 minutes. And how much for Brown?
Probably an hour.
An hour? You hardly were even mentioned.
Sorry.
An hour? You weren't even mentioned, man. You trying to confuse the jury.
You can renew your Rule 29 if that's the attitude.
Right. I agree with that, attorney. Shit, let him go then.
The less you say, the better off you are, probably. No,
The judge has made his decision about that.
No, that's unfair.
I don't have much.
Okay, 3 hours, 90, 90, and an hour.
I'll take 90 just in case.
What? All right. We should be able to get it all in then.
I mean, that's 7 hours.
90/90, the government has to talk about all of you. So they have the burden of proof. Remember that in case you forgot.
Judge, are we going to be able to do that in a day? Mike is telling me no. Not with those time limits.
Let's see. 3 hours and three, that's 6, 7. We'll get it in. We'll make them stay.
The judge is not playing, y'all.
Play.
Do
Woo.
we have an ability to start at 9, Your Honor? Is that not what would that be possible? Would that help the situation?
We told the jury to come back at 10, and I don't think we can call them. We'll cut their lunch hour. Mhm.
You can't do that.
Well, do the best. We'll do the best we can. If they can't, your rebuttal may come on Tuesday morning. But I really want to get it done.
Judge, the one thing I don't want is the rebuttal to be the only thing on Tuesday morning. That's the one thing that I don't think is fair. I don't care how we divide it up otherwise, but we can't have the rebuttal without any defense arguments on the same day.
All right. Well, we'll make them stay late.
Okay.
We haven't made them stay late yet, right?
They got a nice long Labor Day weekend. One more day than they were otherwise going to get.
Okay, they did. Plus, they got the extra day, which made me a liar. I said that hell come high water or finish it. We'll finish in 4 weeks.
We would have been exactly there.
We didn't do it.
It wasn't our fault. We would have been closing right now.
I believe one panel was told by the 15th, Your Honor. So that one, I think you'll still be on track for.
All right. Actually, it's a problem. It's the fault of the court system, the GSA, by making us close on Wednesday. All right. We'll see you Monday. Have a nice weekend, everybody.
Thank you, Judge.
Thanks, Judge.
Thank you. All right, y'all. Woo! I gotta get ready for prayer, y'all. You guys, peace out. I'll be back to do the to do McDavid, but I gotta do our prayer. See
So I
y'all
was just about to say, did I miss the ending, the second half of McDavid?
She didn't read it.
Okay.
because I wanted to do the instructions, jury instructions.
What do you
When,
got?
when,
I know
when
you
we
gotta
gonna
go.
read?
I gotta go do our prayer, okay, y'all? Gotta go
Okay.
do our prayer.
Okay.
You
All
know,
right.
reading this little small little
Bye,
thing.
everybody.
I don't like reading. That's why I don't read because this looking at this little phone here be messing up my eyes. They jacking up my eyes. I can't see.
I don't like the instructions, just to put that out there.
You don't even know what the instructions are, ma'am.
Well, from what I was hearing about the ages and how they were trying to do the definitions, that part, I don't like it. I don't like it. It is
Yeah.
causing confusion.
No, but it's good. So they can have a difference in their age. It confuses them and stuff.
She was fighting against it.
Certain parts of it, she did get the definition to be put in there.
Okay. I talk to you guys later.
Can't win them all, you know that. At least it's come on now. You
Bye.
cannot say this is better than the other one. Come on,
Yeah. We need to win them all.
we're gonna win. We're going to win. Win. Don't be doubting now. Come on
I
now.
didn't. I said we need to win them all. I didn't doubt anything.
We're gonna win
I
them
said them
all.
all.
We're gonna win. They didn't prove
Okay.
it. You could tell they didn't prove anything because they was trying to bring that Barry Hankerson in there so they could slip Elias talk in there.
Mm-hmm.
I wish Daryl McDavid's attorney would have got crossed Barry Hankerson.
I didn't want her Barry Hankerson in there.
No, he was just gonna add more salt, on his name.
Yeah.
Nope. No more negativity.
Yeah,
But
I
boy,
agree.
someone needs to investigate him. I really wish someone would.
Mm-hmm. Defense attorney. Oh, some new tweets just
Okay,
came in.
Cool P, I got all of those to send to you, ma'am. I got everything to send to you. I will send it to you. Give me a few days. I'll send them all the transcript. Shout out to Cool P, y'all. She was her and Nosy Rosie were the two who did a big chunk of the transcript that helped us out. I never made the full amount. I'm still in the hole, but that's okay.
Sylvia, I totally have to read this.
What?
So the feds asked that the judge not allow the transcripts to be used. So, the defense attorneys in R. Kelly trial just offered a sharp retort to the prosecutors a day ahead of the closing arguments. So they just released some motions, I guess. Do you believe they're asking that the jury cannot get?
Wait. You want me to go into the what? The paperwork when I'm about to go do my prayer?
No, I'm just saying. Can you believe that the feds are asking that the jury can't get the transcripts? They're asking that the jury can't get the transcripts. What kind of cheater bull crap is that?
They scared. They scared because they want the truth.
Oh no.
They don't want the truth to be coming out.
That is ridiculous.
These damn cheaters. Who does that? Can they even ask for something like that? They have to be able to pull.
Scaredy cats. Okay, yeah, I have to go do. I could come back and read it for y'all. I can come back and read it for y'all, but right now I need to go ahead and do my
How long is prayer, Sylvia?
1 hour. Oh well, probably 30 minutes. 30 minutes.
Okay, because we need this is important.
Let's send the prayer
Not
out. They're going to rush prayer.
I'm not rushing prayer. I've been praying. I've been to church. We've been to church today and everything. So it ain't like I haven't been. God. Me and God, we got that connection.
Yeah, I know, Cool P. Yes, definitely. That was the other part. Yes, definitely. You and Rosie are the ones that did it, and I thank you guys. Though you two. Not that I don't think everybody else who gave their amount, but you guys gave the biggest.
Yeah.
I appreciate y'all.
We understand, Sylvia.
Yeah, because everybody else gave too. Because I'm telling you, my peeps like you and Henny and Perspective, you guys gave as well. Thank you guys. I'm gonna
You're
do a shout
welcome.
out.
No problem.
I'm about to do a shout out when last day. Give all the people that gave towards the transcript a shout out because you guys helped me. Y'all did the best that y'all could to get this thing out. All
I'm
right.
just trying to figure out in what court did they not give the transcripts to the jury if they wanted them. That's weird. That's weird.
I can't believe they requested that.
They're supposed to have access to it because they didn't put the jury notes in there. They didn't put the what's the name, so they should be able to get it. They didn't put the we call it sidebars, so they should be able to get it.
In my head, the audacity of them asking that.
Oh, you know why? Because there's some decisions that was made behind the scene that they will be able to see, and that's that's why they don't want to see it. They would have to get it redacted.
Okay, let them get it redacted, but not to give it to them at all. That's bull.
I'm sure that they would give it to them only for what they specifically asked for, right?
Yeah. But guys, I gotta go because I gotta get my stuff together for my prayer people. I'm not gonna rush prayer. If it goes past that 30 minutes, fine. But
Okay. Bye.
Yeah.
I mean, we're not gonna be sitting there trying to like get on. You know how back in the days when we were in little, we be on our knees.
I don't know. A lot of people like.
Remember
people
back
like
in
to
little, huh?
I remember that commercial. God is good. God is great. I thank him for this food today. Thank you. Amen. Bye.
Shame
A
on
lot of
you.
people like to drag prayer out,
And they be
God-
singing, making all kind of noise. Let me say, okay, let's stop. Okay, bye, y'all, because y'all about to get me in
God
trouble.
said make it
Bye.
simple and
Get
short.
me in trouble.
Blessings, everybody.
I'll be back.
Bye.
Henny, get those other things ready. So 'cause I don't want to hear about you printing. You need to
I
print.
got everything already.
I don't want to hear about no printing. Perspective, you coming back to help us? I'll send it to you.
Of course. Whenever you need me, let me know.
All right, darling.
What time?
When I finish prayer, I'll send a message out. You got your thing printed.
All right, send me a text. Don't email
That's what I
me.
was going to say. Text me.
Y'all getting on my nerve with this text.
You love me. You love us.
Guys, these people get on my nerve, y'all. Bye, later.
Bye.
Bye.
Bye.